Good afternoon and welcome to today's session. Welcome to Ascent Reality, powered by Ascent Radio. Today we'll be talking property matters as we usually do, and our topic for today is property transactions, defenses to breach of contract. Property transactions, defenses to breach of contract. And today I will be the one to lead this discussion. And my name is Destiny Unuati Ijibo. So we are going to start by telling a little story. This story is about Mr. Oji Adamu. Now, this story is about this person who entered a contract with a certain person, and the person has accused him of being a breach of the contract or sale of land, which they have already agreed to, and they have performed part of this contract, or some parts of the contract have become impossible for the person to perform. So because of that, the other party seeks to enforce the terms of that contract. Now this person is now wondering, how am I going to put up a defense now that this person is saying I have breached some things of the contract? So we are going to be looking at the options available to the person who has been accused of breaching a contract. What are the defenses he can put forward to shield himself in case where a party is now saying you have breached a term of the contract? Now, the first thing you need to look at is the fact of each case. It doesn't really mean that, okay, because there's a breach, you have to apply whatever option that is available. No, you have to consider the facts of each case, because the options that are available are dependent on the fact of each case. The option that may be available to Mr. A may be different from what will be available to Mr. B. Same with Mr. C. So you need to be sure that, okay, this particular defense applies to Mr. A, this particular one applies to Mr. B, and the other one applies to Mr. C. Now, wherever there is a breach, there is always a remedy. Now, as a person who has entered into a contract and you have performed your parts substantially or in whole, but the other person has failed on his part to perform his own, you always have the right to approach the court or any other means to enforce the contract which you have entered. And on the other hand, the person whom you seek to enforce this contract against also has rights to defend himself, and he has lots of options available to him. Now we are going to be looking at these options that are available to the defendant in this case, one after the other. The first one we'll be looking at today is all contracts are to be in writing. Now, if you fail to put down the contracts between you and the other person whom you now seek to enforce this contract against, you fail to write them down, it means this person can always come up to say, okay, because by law it is required that certain contract must be in writing, we did not put this in writing, then you cannot enforce this particular contract against me. Now, the Land Use Act requires that every land transaction ought to be in writing, and the statute of fraud also provides that whenever you are having a contract that deals on property transaction, it has to be in writing. Now, if you fail to put that into consideration while you are entering that contract, the person whom you seek to enforce that contract against can always bring up this defense that you will fail to enter this contract in writing. Therefore, you must ensure that all contracts are in writing, and if there is a failure to put them in writing, you can always bring this as a defense to contracts that have been breached. Now, another thing is indefinite. When the contract seems to be indefinite, what do you mean when you say the contract is indefinite? It means that there is no certainty as to the commencement of the contract or the terms of the contract, certain terms which ought to take effect from a particular date. It is not stated in the contract or sale which you now seek to enforce. Let's say, for instance, you entered a contract of sale today, but you have reduced them into writing, but you fail to insert a date which that contract will take effect. It means that contract is void. you cannot enforce such contract against anybody. So if you seek to now enforce a contract, that let's say you enter the contract to purchase a particular plot of land, but the person ends up selling it to someone else, they put it in writing and they say, okay, this contract will take effect from the 5th day of April. But the way you entered, there was no date that the contract is set to commence, and there is no event which you may say, okay, at the happening of this particular event, the contract will take effect. There is no certainty as to when the contract will commence. Therefore, the contract becomes an indefinite one, and the terms of the contract are not certain, it becomes indefinite. So, as a defendant in a suit for breach of contract or sale, you can always bring up this defense that the contract was indefinite, there was no certainty as to the commencement, there was no certainty as to the terms agreed by the parties. If there is no certainty, that means therefore there is no agreement between parties. Then the other one you can also bring up is frustration. You can always say that the contract between you and Mr. A or Mr. B was frustrated. It means you are unable to perform the contract because of certain factors that are not within your control. It means therefore there are certain events which both parties could not have envisaged while entering the contract. One of such events is war. Another one is riots. Let's say the performance of the contract was that, okay, you are going to deliver a particular building to Mr. B on the 12th day of May 2022. But on that certain date, where the property is said to be delivered to Mr. A, war breaks out. It will not be expected of you that you are to deliver that same property on that date, whereas there is a war going on in that particular location, or there is a riot that is going on in that particular place. You cannot be expected to deliver a property in such a heated period. Another one that could another thing that could frustrate a contract is where maybe the land is meant for agricultural purpose, but due to heavy downpour, erosion flooded the whole area. Now, if that is something that has occurred, that was not envisaged by both parties, that there will be a heavy downpour that will eventually lead to flooding of the area, which makes it impossible for you to deliver that property to Mr. A or Mr. B, as the case may be. It therefore means the person cannot claim that, okay, you failed to deliver the land to him, therefore he wants his money back, or he wants you to forcefully deliver that property to him. It has been frustrated by certain events which no one will expect that you are able to control them. It's only when it is foreseeable that, okay, you failed to do what was required. Let's say it was part of the contract that you are to insure the property, and due to loss, maybe fire incidents, outbreak of war, and all of that, those things were considered during the drafting of the contract, or it was envisaged during the drafting of the contract, then the person can say you cannot rely on frustration. But if all of these were not captured while the contract was being drafted, it therefore means the person cannot bring an action against you when any of these events take place. So you can always rely on the principle of frustration, that the contract was frustrated. There was no way anyone would have expected you to deliver on your part of the contract. Another thing that you can also bring up as a defense is mistake. Now, there are some situations where you intend to enter a particular contract, and it turns out that certain things were brought into the contract which were not part of what you both negotiated. Now, you are entering into this contract because you believe this and this are parts of the contract. Let's say, for instance, you entered into a contract that, okay, we are going to deliver this particular parcel of land within a certain time, and is measuring 40 acres. And after the contract was drafted, you now discover that, okay, the actual land which was being sold is measuring 25 acres. but you reasonably believe maybe because during inspection they showed you this large expanse of land, but it turns out that the owner especially told you that okay, this is what it owns, but you were not fully aware of some facts during the negotiation stage. You can always say okay, there was a mistake as to facts which you entered that contract with. It means therefore that certain things were not part of what you wanted to agree to. So if that is the case, you can always bring up the defense of mistake in breach of contract. Now another one is lack of capacity. Now the position of the law is that before you can enter into any contract, you must have the requisite capacity. Now when it comes to land transaction, there's a certain age that is set for you to purchase land in Nigeria. Different states may vary, the laws in different states may vary, but general law is that you must be of a certain age, 21 in some jurisdiction and 18 in some other jurisdiction. Now if the place where the land is located states that you must be of age which is 21 years of age, but in the circumstance the person that is selling is not up to 21, or the person that is buying is not up to 21, it means that person lacks the capacity to enter into such contract. And if the person lacks capacity to enter into the contract, he cannot enforce any of such contract that he doesn't have the capacity to enter into. Also, as a defendant, if a minor sells a property, you cannot enforce that contract against that person. Similarly, if a minor purchases a property, the person cannot have the contract enforced against him, because purchase of land is not a necessity but a luxury. Now, if a person is going to purchase a property, it means the person must have that requisite capacity. Another thing is the person might be ill at that particular point in time. Maybe the person is of unsound mind. If a person is of unsound mind, it means the person does not have the capacity to sell any property. If you enter any contract or sale with any person who is of unsound mind at that particular point in time, there are some persons who may be sometimes they are of sound mind, and at other times they are not of sound mind. If it happens that at a particular point in time you entered into that contract or sale, the person is not within his lucid period, that is not within the period that is usually on the sound mind, you cannot enforce that contract against that person. The person can always bring up that defense that at the time the contract was entered, you didn't have the requisite capacity to enter into that contract. Another one you can also put up as a defense is that there was fraudulent inducement. What does it mean? It means that the person that is seeking to enforce this contract has hidden certain things from you at the point of entry the contract, or he influenced you to enter the contract maybe due to some certain promises or threats. If this is the case, you can always bring this fact that the person who seeks to now enforce this contract brought about certain things into the contract which ought not to be there ordinarily, and you enter this contract because you believed certain things were true, but you later found out that these things which the person represented to you were in fact untrue at the time of entering the contract. Now, let's say for instance, a person comes to you and tells you, okay, I want to sell a particular parcel of land. I am the owner of plot A, Akiyode Road. Now you enter into the contract believing that the person is the true owner of that property. But in the end, after you have made payment, or let's say a deposit, you now find out that the person is not the actual owner, or the property is owned jointly with some other persons. You can decide to withdraw from such a contract. Now, if you have withdrawn from that contract, the person cannot sue you for breach of contract because he has failed on his part to represent facts as it ought to be. Another thing is the contract is unconscionable. What do you mean when you say a contract is unconscionable? It means that the terms of the contract are unfair in the circumstance. There are some terms that may be brought into a contract, maybe because the person who is selling is an illiterate. So because he didn't have enough knowledge about how contract works, the person who is educated and a buyer decides to insert certain clauses into the contract, which leaves the vendor without anything to show for the contract which he has entered. It means the contract becomes unfair. Maybe the plot of land which ought to be sold for 15 million, for instance, the person decides to, because of the ignorance of the person, says, okay, because he doesn't know much about money, let me buy this land for 2 million naira. So if this is the case, it means the person has taken advantage of you. In another sense, it could be that the terms of the contract which this person, the purchaser, made you to sign is that you are to give up a certain percentage if you do not deliver the property within a certain time. Let's say there are tenants in the property and their tenancy is to expire, let's say 6 months after the contract was entered into. And upon entering the contract, you explain all of these things to him, and he decides at the end to insert any clauses which is, if you do not evict the tenants within 2 weeks upon signing the contract, whereas the tenant still has 6 months, then he is going to take out, let's say, 2 million from what you have bargained. That contract becomes unconscionable in the circumstance because he has made it unfair to you. Another thing you can also rely on is duress. Maybe you were compelled to sign the contract because you were at a disadvantaged position. A good example is when a government official, maybe because he has access to so much power and some other persons who are in authority, he decides to compel you to sign a contract giving out a large portion of land which maybe you have inherited from your forefathers. He decides to use his good office for some other purposes other than that which it ought to have been used for. Now, you can always say, when you say you don't want to enforce the contract, that the person that made you to enter that contract, you signed under duress. You were compelled to sign such contract, and if this is the case, you can always tell the court, because this contract was not entered into willingly, I am unable to perform my part of the contract. And the person decides to say, okay, you must sign. That is why you signed. You have to show the court that truly the person compelled you to sign that contract for you to hide under this defense of duress. Another one is undue influence. Undue influence is usually when a certain person has unfair advantage, or the person is at a position where he has the authority or power to influence the decisions that you make when it comes to property. Let's say, for instance, an uncle who knows that a niece or nephew of his is in need of money to finance his education. Then this niece has a property that is worth, let's say, 5 million naira. He decides to buy the property for 500,000 because he knows this person trusts him so much, and because of that trust that that person has in him, he decides to take advantage of the trust. Or he decides to say, okay, because I've been the one sponsoring your education, if you don't sell this land to me at the sum of 1 million naira or 500,000, as the case may be, I will no longer pay your school fees, and all the benefits and privileges which you have been enjoying for a very long time, I'm going to withdraw all of them. So that person is taking advantage of the influence he has over you. And if that is the case, you can always hide under this defense that the person who seeks to enforce the contract exerted undue influence in the signing of the contract which he now seeks to enforce. Another one is you can always rely on is waiver. Now, how does this waiver work? Now, when you are drafting any contract, there is always this clause that say, if certain things happens, you have period to bring an action or to notify the other person that you are in breach of contract which we have signed. Let's say, for instance, you enter into a contract that is worth 500,000 naira, but the person who is unable to pay the full amount decides to say, okay, we are going to structure this payment in 4 bits. I will pay first installment on the 1st of January, second installment on the 3rd of March, and the fourth installment on the 5th of June. Now, if all of these things have been outlined and it is stated there, if the purchaser fails to make payment on a due date, he shall forfeit that part which he has not paid for. And the vendor has to give the purchaser notice of that breach. And if the purchaser fails to perform his part of the contract after being given notice, he has waived his right to collect whatever he has paid in respect of that particular contract. Now, if you have such clause in that contract and the purchaser fails to activate that clause at a particular point in time, therefore means he has waived his right to exercise that particular clause which is part of that contract or sale. Now, on the other side, the vendor can also rely on that the purchaser ought to have made payment within so time, and because he has not made payment and he has not given response to the letter which he has sent to him, therefore he has also waived his right to enforce the contract where the vendor fails to deliver the property to him at a particular point in time. Now, in summary, when we are talking about breach of contract, the defenses available to a party who is accused of a breach of contract, you must ensure that you have done what is reasonably expected of you to be done at that particular point in time. It is when you have performed all of these acts that are expected of you that you can come under any of these options that we have highlighted. Failure to do any of that which is required of you, you cannot hide under them. And you must also ensure that you fit your situation to all of these or any of the options that has been highlighted. Now, it can be frustration, it can be undue influence, it can be, or the contract can be deemed to be unconscionable. You have to show why you believe the contract is unconscionable. You have to also show that the contract was frustrated. How was it frustrated? You need to show all of these before you can successfully defend yourself in the case of breach of contract. So that is how far we can go today. You can follow us on all our social media platforms to get more of this discussion. The discussion will continue on our social media platform. You can always leave your comments on any of the issues or any of the options that you have raised. If you have any questions, you can always send them in. We are ready to answer you at any time. Thank you very much for being part of today's session.